So today is the date and time set for a notice of workshop to solicit comments on amending, repealing regulations and determine the impact of the proposed regulations on small businesses. I'll call the meeting to order. Let's do our pledge of allegiance. If Member Decker could lead us in the pledge. Pledge allegiance to the flag of the United States of America and to the republic which stands one nation under God, indivisible, liberty and justice for all. Hey. Ms. Webb, have we complied with all of the requirements of the open meeting? Okay. Keely, are we good? I concur. Okay. Then let's proceed with Dan. Are you going to do this or am I going to do this?
I can take a stab at it, and if there's technology problems, then you can jump in. Is that okay?
Yeah, that's fine. Let's do
Great.
that.
So before us is LCB file number R006-25. Proposed rules. These have been were previously workshopped before the board, sent to LCB, and LCB provided us a draft and comments of December 3rd. Some of our proposed rules were not accepted. Ms. Webb, I think it is largely the attempt to set up a manual for the accounting, and there was not anything else material that they declined to provide a draft of, correct? The purpose of today is to again workshop the proposed regulations and accept comments, changes and additions that folks would like to make. My planned way of proceeding is first to allow staff to address us on any sections that they want to make comment or changes to, and then open up for public comment sections for public comment, and then bring it back to the board for discussion and comment by the board. Is that an acceptable way forward for the other board members?
Yes. Yeah, we just need to splice in the small business impact discussion also.
Yes. I think we'll close with that, because we may get comments about on that subject matter, Vice Chair, when we do a page turn. So a quick page turn. So Administrator and Ms. Webb, are there any sections that you want to identify and indicate where you think there are changes necessary?
Thank you, Chairman. Can you give me just a moment? We're going to speak with somebody from the Labor Commission real quick.
Oh, okay.
See if we need it.
Who's here talking about right now?
Leah, she's the deputy.
I think they're interested in section 29(3)D.
Thank you, Chairman. At this time, no, we don't have anything to talk about.
Okay, well then let's open it up for public comment, and I will preface this by indicating that section 2 through 16 are new provisions, and they largely deal with procedural and governance issues before the board and the authority, and I think are good process improvements where we have identified since 2021, some areas of concern. And sorry about that. I had that on because I was getting calls from guys. So I think we'll just go. Are there any public comments on section 2?
Public comments.
Pardon? Is there somebody coming up to comment on it or no?
Possibly.
Possibly.
Okay.
Clear, are we commenting on, sorry, I have to interrupt us from current ability. Are we commenting on this document yet?
No,
yet.
no.
Nope.
We're going
just
we're going through LCB file R00625.
Yeah.
We'll talk separately at the end of that discussion on the proposed amendments that I drafted relative to pilot program. Okay, no comments on 2. Any comments on section 3? Any comments on section 4? I have one question for the administrator and Ms. Webb. In section 4.1, it is now contemplated that you are going to implement a docketing system where you're going to provide numbers and docket your, all pleadings and papers. Have you given any consideration to the mechanics of how you're going to do that and any costs associated with it?
I don't think it's gonna be a problem. We really don't get that many filings.
Okay. Okay, great. Just wanted to make sure. Any comments on section 5? Any comments on section 6? Any comments on section 7?
Just
Comments?
as we're going, we would interrupt you, Dan, just so the record. If anybody
sorry?
had,
Okay.
nobody had, it's on those
Okay.
last.
Section 8. Section 8 begins some sections I just want to point out to the board and the public to deal with the fact that the authority doesn't have today a robust set of rules that deal with confidential information. And we've had to basically handle this on a ad hoc basis. And this section, these sections through 16, I think provide important provisions to deal with that issue and how we will deal with confidential information in proceedings. We've had a couple of proceedings where this has been a challenge, and I think this is an enhancement. I do have a question to the administrator. In section 12.2 and 10 and section 16.3, the LCB has used has inserted a concept that certain information and filing and pleadings are disclosed only to or served only upon the staff of the authority. And I'm wanting to know how that will be, who is that? And the reason I'm asking that is this has definitely been gleaned from the Public Utilities Commission and the NTA and a couple of other agencies where they actually have a division called staff. And I'm wondering for us, who does that mean? Because some of this is going to be very potentially highly proprietary information. And I don't know that we want staff to mean a clerical employee. And I'm wondering if we need to elaborate on this term.
Chairman, I also agree. By definition, I think the authority is the board. And I'm identified as the administrator. And if we're talking about my staff, I think it would be up to me to determine which staff members would handle the confidential information. So I agree. I think we need to probably address that a little.
So I think, Ms. Webb, wherever it says staff of the authority in those three sections, 12, section 12, sub 2, and 10, and section 16, sub 3, we probably should say served on or provided to or available to the administrator. And the administrator is already defined as Todd or the incumbent or their designee. So I'm comfortable that cures for the observation the administrator made.
That would be consistent with NAC and NRS definitions of the administrator throughout.
Right.
Correct.
Go ahead.
Yeah, before we leave that item, do we have a definition of served?
Taxi cab authority doesn't have branches. I don't think that's ever.
I know, that's why I'm asking.
Well, I think we have a rule that requires a certificate of service.
Okay. I was smiling when you were reading section 2 and 10, because that was the only thing that I had highlighted in here was 2 and talking about served and how served. And so I agree with you. It needs to be addressed.
Yeah. So, Ms. Webb, will you take as one of your assignments to make sure that there's not a hole there?
I'm sorry, I missed where we were at. Where were we at?
Section 12,
Okay,
subpart 2,
okay.
where it's served, and if we can see that if there's in the regs a definition of serve or service, how served.
Which I believe there to be, but I want you to confirm that. Not necessarily here on the fly, but before we send back comments.
Thank you.
But Member Graff's or Vice Chair Graff's comment is well taken, because there are problems with other agencies that don't make clear what and how to serve something. Any any comments on 10, 11, 12? Taking us to 13. Any comments on 13? I have a question under 13.2. And I'll give you, it's probably a Ms. Webb and administrator question. Do we need a timing, a temporal requirement unless otherwise agreed by the parties involved? Require that a portion of the prepared which may address the confidential information be submitted to the party who had requested that information before the date on which the prepared testimony is submitted to the authority. I would be more comfortable if we had has to be provided within a number of days preceding it, so that it's not like sent at 11:59 a.m. and then the testimony is filed the next morning at 8, and there's no reasonable period of time to take any action to protect the confidential information before it's disclosed in a piece of testimony. And it seems to me that 3 calendar days or 5 calendar days? Am I, does this seem like a reasonable issue?
Business days.
I was gonna say minus the holidays and weekends, if we went 3 or 5, I think would be good.
Well, Ms. Webb, you can correct me if I'm wrong. Usually the, our experience with getting the testimony filed on time is a bit of a, you know, the parties are rushing and whatnot. So I would think that the 3 days is probably more practical, that they wouldn't really maybe be in a position to know 5 days out. So I'd be comfortable with 3. I don't know if other board members have a feeling it should be longer than that.
Do we need to make it 5 just because of the Nevada records request? Nevada public records request.
Yeah, no,
gives
I get your,
you 5 days.
my thought there, Vice Chair, is probably they're not connected, because in this instance, it's where, let's say, an intervener knows that there's some piece of proprietary information that they have seen in a protective order context that they want their witness to say, well, given XYZ, this is my conclusion, or that element of the regulation can't be complied with. I don't think they would be looking to use public information. It's how they're going to use the confidential information.
I was just making the suggestion as analogy more than just.
Okay. Well, yeah,
Now-
that's what,
That the legislature, created that statute, gave 5 days for the response by an agency, maybe
yeah, I get you. Yeah.
that's minimum time for a response or a comment regarding confidential information. That's my only comment. That's all.
Got it.
Yep.
I'm equally comfortable with 5. So, unless somebody else feels differently, let's use 5. So I think that change would be, unless otherwise agreed upon by the parties involved, comma, require that the portion of the prepared testimony of a person which may address the confidential information be submitted to the party who has requested that information not to be disclosed, comma, at least 5 calendar days. And then before the date on which. Anything else on section 13? Anything on 14? Anything on 15? Anything on 16? I have one question on 16 subsection 3. It says information which is the subject of an agreement or protective order will be provided only to the staff of the authority. That seems, it seems inconsistent with the fact that there could be a protective agreement which would allow other parties to see it. So my thought was that it probably should say, except as may be otherwise provided by an order of the presiding officer or the authority, comma, lowercase I, information which is, and then it would be not staff of the authority, but the administrator.
Or agreement by parties, like that.
Pardon?
Or agreement by all parties.
Or an agreement, you say? Well, this agreement or protective order clause is being used throughout as being the agreement that's referred to earlier as an agreement of the parties as to how to deal with confidential information. So if you want to say agreement of the parties, I don't have a problem with that. As other members of the board are aware from previous proceedings, some of which were last year and some were a few years ago, we did have situations where we only saw information. We, the board, only saw, and the administrator saw the information, and other parties expressed concern that there was no process by which they got to see it for the purposes of cross-examination. So I think we need to have an outlet here. Anything else on 16? Anything on 17? 18? 19? 20? 21? 22? 23? Somebody coming up?
Sorry, Chairman, I'm just talking to Ms. Webb.
Okay, 24. I'm sorry, 23. I had a suggested change in 23. Administrator, are you with me?
Yes.
Says whenever a taxi cab is involved in a crash, I would like to suggest that crash be stricken and we put in either the word collision or accident.
Not
I'm not,
accident.
huh?
Not accident. Accident is a term
That's
that
what I
is
wanted.
intent of any, so collision or crash, but we don't use the word accident in.
Okay, great. Thank you, JD. That's why I didn't know, because I thought accident was too broad. So I would prefer a collision because I don't know if a crash entails something. I'm not sure that that's a term of art in any of our statutes. That's all.
Collision would be a good one.
This word has been talked
Yep.
about
Yep.
extensively.
Many times.
I like the word collision as well. I also agree with Member Decker that the word crash is not appropriate here.
Yeah, okay. Okay. Anything in 24? On 24.2, I believe that the term authority at the end of that should be administrator. Any taxi cab found to be in violation of the section of the authority will be placed out of service and put back in service until inspection and approved by the administrator, because this wouldn't come before the board.
I agree.
Yeah.
Fraser, may I just make one comment? Overall, Yonit Welburn, NTA Administrative Attorney. As I'm listening to your regs, I keep hearing it referred to as the authority, and that might cause some confusion because under NRS 706.016, authority is actually defined, and it's defined as the Nevada Transportation Authority. So in your regs, you might want to change the word authority to taxi cab authority.
Actually, Actually, I believe the statute applicable to us defines authority differently.
Okay, I just want to make sure because because I know they're seated similarly and because the NRS has a definition. And when you look at the NRS for the taxi cab authority, it always says taxi cab authority. It never says authority.
Our NACs at 706-450 says authority means the taxi cab authority created by 706-8818.
Yep.
Okay, because that is,
Yeah.
I just saw the confusion. So I just wanted to make sure that that was complete.
Yeah. Thank
I would
you.
agree. I think explicit clarification between the two makes sense. I mean,
Well, yes, but until the department revises chapter 706 of the NRS and chapter 706 of the NAC, they both refer to the authority in the different sections as meaning either sections referring to the NTA as the authority or the sections referring to the board and the agency as the authority when it comes to the taxi cab. So that would be consistent with how it's written. I'm not saying doesn't need to be revised, but I think we're starting to revise it now would be confusing if we don't touch the rest of the NAC.
Yeah, I think we have a defined term already.
Okay, apologies for that. I just didn't see the definition of authority in the NRS, and I did see it for ours. So I just wanted to make sure everybody was very much aware because the NRS only says taxi cab authority. So it's interesting that the NRS only says taxi cab authority, not authority, but your NACs say authority.
Yeah, look at 706.8818, like Ms. Webb said, and it will talk about taxi cab authority.
Right. But it always, if you look through the NRS, anytime it talks about the taxi cab authority, it says taxi cab authority. It doesn't say authority. So that's why it seems confusing.
So is the comment
Rest.
that, is the comment,
And I
Yeah.
didn't see, I'm sorry.
is the comment that we should tell LCB that they should go through and everywhere in NAC 706 change authority to taxi cab authority?
Those confidentiality statutes, which is what piqued my interest, are the NTA's confidentiality statutes. So
Yep.
when you're saying authority, and they're the exact statutes of our statutes. So when you're saying authority, it's kind of confusing because we are defined as the authority by the NRS. I know the NACs define you as them. It's just so confusing because there are two, there's the Nevada Transportation and the Taxi Cab Authority. I apologize, I have not read through the Taxi Cab Authority NACs, but in the NRS, when it talks about all of 706, the only person who's referred to and defined as authority is the Nevada Transportation Authority. I'm not saying one way or the other. I'm just saying it's very confusing because the definitions under taxi cab authority do not have authority as defined. So even though it's the practice, the NAC over here, if you look at the NRS, there are a bunch of definitions. Administrator is, but authority is never defined. Chairman, if you think it's fine, that's fine. It just seems a bit confusing to me because authority has an actual definition in the NRS. And I don't want people to say, hey, taxi cab does not have an authority in the NRS where the Nevada Transportation Authority does.
Yeah,
But if you're comfortable with the NAC, that's great.
So I'll tell you, just so before we end the conversation, and Dag freely can weigh in here too. The reason I'm comfortable with that is frankly for the purposes of the taxi cab authority's jurisdiction, authority is not defined by the statute at all, and nor is it defined by your statute, because the definition of authority under 706.018, which applies to the Nevada Transportation Authority, is only applicable to 706.011 through 706.791. It does not have applicability outside of those provisions, and our provisions are not, the taxi cab authority is not within those provisions. And I believe that's why initially the taxi cab authority had to define by NAC
In fact,
what
Chair,
authority meant, because the statute didn't define it at all.
Okay.
Chair, if I could read section sub 3 of 706.881, it says, with any such county, the provisions of this chapter which is the 706, which confer regulatory authority over taxi cab motor carriers in a county which population is over 700,000 or more. The authority of the Nevada Transportation Authority do not apply.
Yeah, right.
So it's saying very specifically, everything after 881 is taxi cab authority.
Right, and that's fine. I'm just saying those NACs, yeah, that's fine. They were just confusing because they are exact NACs and they keep referencing authority, and I didn't want anyone to be confused, and especially because there is a regulation in there that says someone who needs to appeal a decision has to come before the Nevada Transportation Authority. And if you start writing in authority, well, which authority are you referring to? So as
Yeah.
long as there's clear definitions everywhere as to which authority, that's great. And it's,
Yeah, I don't know what LCB would do, but based on experience, I think they might say we're not going to change it because we think it's clear.
okay,
Okay.
thank you Ken, for the time.
No, thank you. Anything else on 24? Anything on 25? Anything on 26? Anything on 27? Administrator, I have a question on 27, 1K5, which is on page 25. Automatic locks which control all doors and which are operable at the driver's or independent contractor's door. Does this mean that the passenger can't unlock their door?
No,
Okay.
no, they can still unlock their door. Otherwise, it's kidnapped.
It means the driver has to be able to
No,
lock
it's
all-
more, I was more concerned about a collision. Driver is injured and can't hit the button and let them out, and and they can't extricate themselves from a car that's been in a collision. I just want to make sure that's not how that worked. Okay. Thanks for the clarification. Anything in 28? 29? My understanding, Ms. Webb, is that there might have been some comments on 29 3D being deleted. Do we still have an issue there?
I would say this, we were contacted by the workers' compensation, the Labor Commission, excuse me, regarding the leasing to, employees being allowed to lease from their own certificated carrier. And, but after we discussed with them, I think they are okay with us leaving the way it is, but that does not forbid them from enforcing the workers' comp rules. So, the way
Okay.
we drafted for LCB is still okay. It's just they,
Okay.
have decided that they will still enforce.
Say that again?
So, we had discussions with the Labor Commission to remove some language that we have in our grant from NACs. But we've been advised today that they are actually okay with leaving them stand the way they are as originally drafted, the LCB, because they can enforce anyway. So I guess the decision is for the board whether we want to, in effect, allow them to do that, or and then have the Labor Commission enforce or not. Yeah.
Dan? Do you have thoughts on that?
So I'm not sure I want to make sure I understand. Are you saying, Ms. Webb, that we would be allowing it, but the Labor commissioner would not be allowing it? Is that what you're saying?
They just told me that they feel like they can enforce it anyway, no matter what we wrote. So it in effect depends on what an audit would show. Whether they're doing
So
it.
it's the labor commissioner's position that an employee driver cannot lease a cab from their employer, but they could from another certificate holder.
They do have concerns about that, yes.
We've had. I'm gonna let them talk about this, I guess. I think we have people that want to comment on this, Dan.
Okay, yep.
Cheryl Gibbons for Desert Cab in Virgin Valley. I guess my question would be specifically, what concerns would the Labor Commissioner's Office have with tax cab authority regulations that have to do with an independent contractor that they would have no purview over? I'm a little thrown by that. Because as an independent contractor, they're not an employee.
I was directed to NRS at 608.0155, the independent contractor laws. And that's really as far as I can go, but I'll give you my copy back.
Oh, that's okay.
Okay.
I'll look it up.
But I think,
So
go ahead.
I guess my problem would be the Labor Commissioner's Office would have authority over an independent contractor relationship with Desert or Virgin Valley as an independent contractor. By the same token, they would have the regulations that apply toward an employee relationship for an employee with Desert Cab or Virgin Valley. So if Cheryl as a driver were to be an employee 3 days a week for Desert Cab part-time, Labor Commissioner's Office would deal with those earnings as an employee. If Cheryl then decided to lease from Desert or Virgin Valley for 2 days as an independent contractor and file the complaint with the Labor Commissioner's Office, they would then deal with that complaint under the auspices of an independent contractor. Am I correct?
Well, I'm going to leave that to that we have members of the Labor Commission here today, and if they'd like to introduce themselves for the record, and potentially make their understanding.
Good morning. I'm Malia Tatum, Deputy Labor Commissioner for the record. We did originally reach out about some of the verbiage because it appeared to kind of conflict with some of the way our office looks at independent contractors or potential misclassification. But from the further review and looking into it, we see that it wouldn't really affect how we would look at these issues if they were to come into our office. So we just wanted to make sure that our statutes weren't conflicting. Because we have an economic realities test also that determines what is an independent contractor and what could be an employee. So we thought them leasing the vehicle, being in the same type of work, with the same individual that is their employer at a different time of the day would maybe conflict. But we've spoken with our legal counsel also, and they've stated that these changes wouldn't change what our economic realities tests also say. So it would it wouldn't affect anything on how our office would look at a case if it were to come in.
And just so for context, this would avoid an absurd situation in which the employee of one carrier in his off time is leasing a cab from a different carrier, and then puts the carriers in competition with each other for the same employee. Is that correct? Sure.
Not only that, it's, to put it in terms that everyone understands, it would be no different than someone being an employee and then going to work for a TNC as Desert being the employer or the person that is leasing. I have no way to determine if that individual is working for Yellow Checker Star, how many hours they've already put on the road versus how many hours they're in my vehicle, to make sure that we, abide by the 12-hour daily limit that these guys can drive and the 8 hours in between shifts.
So originally we thought maybe it would conflict with how we would look at things, but the more we've looked into it, it really wouldn't.
But you're not giving any determination that you're going to say that it is misclassification or not here today.
No,
What you're saying is you're still going to look at it on an independent basis in each situation.
exactly.
But you're
I'm
not
fine with
opposed
that.
to the language as it's.
We're not opposed to the language.
Okay.
That's,
We've had, I mean, and Chair Reeser can tell me I'm wrong, or Ms. Rushton can tell me I'm wrong, but we've had this issue come up and we changed things so that we could address the issue of independent contractor versus employee so that we could have a situation where there's a two-hat situation. I have had contact with the Labor Commissioner's office on the issue of misclassification. It is not my experience that they allow the two-hat situation. So that's why I'm making it known right now that the taxi cabs under our regs can have drivers that wear two hats, that wear the hat as an employee and wear the hat as an independent contractor. That's what we intended, and that's what our regs and statutes intended. So if what you're saying is you're not going to allow that, you need to say it now at the workshop.
I don't think we could say either way, that we definitely wouldn't allow it or would allow it. Just like how every complaint is with our office, it would be on a case by case basis and we would have to take a look at things.
I get it.
Yeah.
But eyes wide open, everybody hears it, everybody understands it.
Mhm.
So that's why I wanted to make sure that Cheryl was aware that I think Cheryl was thinking she was getting an answer to the question and she's not getting an answer.
No, the answer that I assumed I would get is the answer that I did get, which is Labor Commissioner's Office is going to investigate any complaint that is brought to them based on the merits of that case and go forth as they always do.
but I don't see that. I'm sorry, I didn't mean to interrupt if you were still.
Nope, I think you're good, Dan.
Okay,
Go ahead.
I don't see that as prohibiting, or I don't see that as creating a conflict with what we are trying to achieve. What I actually, my interpretation, similar to Vice Chair Graff, is what this goes to is whether the independent contractor is a bona fide, in relationship is bona fide or not, and whether or not it both complies with the Labor Commissioner's rules and our rules for them to be an independent contractor, which goes to what the lease terms are. I mean, I think it's a fact specific, and I wouldn't want to. I'm prepared to go forward with this deletion of this understanding, just so the certificate holders understanding that the Labor Commissioner may say, great, yeah, you can enter that agreement under your taxi cab authority rules, but we're determining that in this specific case with this specific driver under this specific contract and under these facts of how you're actually dealing with them on a day-to-day basis, they're not really an independent contractor. I get that result could occur, and everybody needs to just understand that. That's not a reason not to get rid of the absurd result, to quote Member Decker, that does exist and why we're making this change.
Exactly. That's what we're saying. The change in the act, that's not going to change anything that our office would do. So exactly what he's saying is that's what we agree with.
Okay. Other board members have questions? Any other clarification, Administrator?
No, that's my understanding as well.
Thank you.
Thank you. Section 30. 31. 32. 33. 34. 35. 36. Administrator, a question on 36 subsection 4. Not permit more than 2 passengers in the front seat of the driver's or independent contractor's taxi cab, and not permit more than 6 passengers in his or her taxi cab at any one time. See that language?
Yes.
And this probably would have gotten by me, except for we changed 5 to 6. Why wouldn't this rule say not permit more passengers than there are seat belts?
This was brought up because of the new SUVs and vans to allow for the amount of seatbelts in the vehicle. But I think we could also start getting into language that would make it a limo instead of a cab.
Oh, so that's why we're specifying passengers,
Yes.
number of passengers.
Yes.
Well, as one board member, I'd feel more comfortable with this subsection if it said, or some lesser amount equal to the number of, or that does not exceed the number of seat belts. Because the way it's written right now, it implies that I could put people in. I mean, I know there's another reg that requires a seat belt, but does this somehow conflict with that? I guess maybe it doesn't.
I don't. That's
I mean, am I in agreement? Are we in agreement, Administrator, that if you pulled somebody over, they complied with subsection 4, but somebody didn't have a seatbelt on, there would be a violation?
yes.
Okay, then I'm okay with this then. Thank you. I just wanted to make sure that there wasn't a loophole for seatbelts. Anything in section 36? I'm sorry, 37. 38. 39. 40. 41. 42. I have a question on 42(1)(f)(4)(2) at the bottom of page 35. Shall return the taxi cab to the certificate holder not less than 1 time per week to enable the certificate holder to comply with these requirements. Do we have another provision that if the lessee, if the independent contractor determines that there is some operational issue with the vehicle, that they don't get to wait the whole week?
That the inspectors are able to call them back whenever needed.
Okay,
So this was for an independent contractor to not have to show up to the office every single day, but once a week, and then otherwise our inspectors can call them back whenever needed.
but if the independent contractor has a check engine light on, and they only have to bring it in at the end of the week, is there anything that makes them bring the vehicle back earlier than that to make sure that that there's vehicle integrity? That's all I'm trying to figure out.
I can take that. Curtis Mel, Deputy Administrator. There are other provisions for if there are issues with it, they are to return to their
Okay.
company.
Okay, I just wanted to make sure I was right about that. Okay, thank you. Anything on 43? I have a question on 43.2. We're doing away with the requirement that they have a separately maintained account. And I agree with that, but will they have to have a separate accounting entry that shows these deposits?
By the lease.
Does anybody have any idea if that's the case?
Some of the accounts, is that what you're asking?
Yeah, in the book of accounts, will these deposits be reflected? Does anybody in the industry know? I don't want them to have, I want to achieve what's done here, but I also want to know, is there a way for the administrator to know that there's $100,000 in there and that the that the certificate holder is properly accounting for the obligation they may have to refund that money and not spend it?
So, yeah, and I guess my question would be, other than just knowing that that vehicle is the leased vehicle, do we have copies? Does the authority have copies of the lease agreements?
Yes, we've approved the templates of the lease agreement.
There could be templates or.
Templates, but I mean, my point is are there variables within those agreements that changes any of the amounts?
Yeah.
And timeframes, that sort of thing. Do those change?
They can.
Okay. But I think that's what Dan's asking. Tell me if
Yeah.
I'm wrong.
No, no,
But
you
Is to be monitor any of the actual termination, return of security deposit, amount of security deposit, that sort of thing.
guess I'll ask it a different way. Administrator, if some independent contractor came and said, hey, I didn't get my reimbursement back, would we have the ability to assert jurisdiction? And I assume we would, because we have jurisdiction over the lease.
Yes, we
Yeah.
would.
Okay. So I guess I'm comfortable with that. I just want to make sure this didn't result in us losing jurisdiction and not having the ability to protect the interest of the independent contractor. Okay. 44. We're almost done with this pain. 45, 46, 47, 48, 49, 50, 51, 52, 53. Do any board members have any other questions or concerns, comments? Any other member of the public have any other questions, concerns on file R00625? Okay, so the next item under this agenda is whether or not to submit any new amendments to our 00625 that are not captured in there. Does the administrator have any something we've forgotten that we need to get in here and send back to LCB other than the document I provided you?
No,
Any board members have anything else they're hankering to put in here?
No.
Any member of the public have 25 pages of additional stuff they want added? I don't see anybody beating okay. So then the only other topic of discussion that we've had on previous meetings is that with regard to the pilot programs, when April comes, we have an Attorney General's opinion that says you need to address some issues, at least 4 main issues, as I recall, before you can do this permanently, or before you should do this permanently. We didn't receive any, in the comment period, we did not receive any suggestions from the industry how to make the pilot programs permanent. I took it upon myself to take a stab at addressing Dag Feely's previous advice and some of the issues we've discussed, and that is this document that I think has been made available, correct? Yeah. I do not represent to my fellow board members that this is the end all or be all. It's just a first swing by me of what I think we may have to do. And unless there's not an appetite for it, I thought I would just go through it briefly.
And Chair, before you do that, just gonna say this for the agency. I appreciate you writing this. I think you did an excellent job. I just don't see how it overcomes 706.88499 in the NRS. I'm just not seeing that. So I'll leave that up to the agency and LCB as to how you want to deal with that, but I just wanted to put that on record.
Or you're saying NRS 48?
Yeah. 706.8849, which essentially says that taxi operator will not act as a TNC.
Right. Yeah. So I think that's the nub of the issue for the AG's office. Remember, Decker, you and I've spoken about that offline. And I think this will, if we were to proceed with this, it would also serve the purpose which you articulated earlier, which is to have the LCB tell us if this is even plausible. Because they've got to determine whether or not there's legal authority to do this. So I do not offer this as being a representation that we are able to do it. It's just a matter of if we're able to do it, how would we do it? So we can either take comments on this, or I can provide a brief summary, however folks want to proceed.
Chair, I have a couple comments in this section. So since there are only 8 sections, maybe we can go through.
Sure. Through comments, or you want me to summarize? I didn't.
But well, you start with a summary, please.
Okay, so this isn't going to take long. Provided a couple of definitions, what is an electronic ride-hailing system, and provided a definition of what a transportation network company is to make sure it's somebody who's licensed. Section 3 proceeds from the assumption we don't have jurisdiction over TNCs. So the only jurisdiction we can assert is over a certificate holder. And the mechanism that I am suggesting that by which that would be done is that they have to bring forward an agreement that gives them access to the electronic ride-hailing system of the network company. And subsection 3 provides for what that some at least my first cut of the minimum requirements we should have in that agreement. And I am certain the administrator may have other suggestions here based on the fact that he's been actually stuck with doing this mechanically for the pilot programs, he and Curtis. But also provides that that agreement has to be approved by the administrator. And if the administrator can approve it, disapprove it, and if it's disapproved, limited, or conditioned, that there's an appeal right to the board. Section 4 is my swing at addressing the Attorney General's advice on the moonlighting rule. I don't know if this is adequate to get there, and I'm not asking you, Dag Healy, to do this on the fly, but that's the purpose of 4, is to address the moonlighting problem. Section 5 is perhaps not required by the Attorney General's advice, but I think board members and administrator, we need a section that says what are kind of the minimum requirements that you want to impose on the communication technology through which the TNC's system plugs into the taxi cab authority, the taxi cab certificate holders technology, captain, curb, whatever. What are the minimum requirements you have for that? Because this goes in part, I think, also to the Attorney General's comments about you need to pay attention to the taximeter regs and statutes. And I frankly am struggling, and that's probably because I don't have full visibility to the yeoman's efforts administrator and deputy administrator that you've had to engage in to get the pilots up. But I think you may need something in that space. Section 6 goes also to the taximeter provisions to make sure that that you determine that the functionality is providing the same comparable information for passengers and your purposes, or you're giving you the power to grant some kind of a waiver or deviation from that standard or from those standards, so that we don't have any issue where we're not complying with the taximeter requirements. Section 7, others may disagree, and I understand. Philosophically, I think the board should want to receive an annual report from the administrator of statistics he requires of the certificate holders that tell us how this is continuing to work, whether, as we discussed this morning, we're still getting enough rides to make this worthwhile, and that the average revenue is such that it's reasonable, and that all taxes and fees are being paid. We may even want to know what progress the certificate holders are making, or their technology providers are making, in developing an independent system that wouldn't require them to use a TNC. And then Section 8, which I consider one of the more difficult provisions, is how are we determining rates, charges, and fares? And what this simply says is that the certificate holder has to file with us, because we don't have jurisdiction of the TNC. Whatever was filed with the NTA before they start, and that those rates, charges, and fares become ours And they have to be in the rates, charges, and fares have to be consistent with what has been filed with the NTA. That's the summary on this last provision, subsection 8. I have learned from an inquiry I made to another regulatory body that section 8 might be, we might have to massage that the certificate holders may not be given access to what was filed with the NTA because some of it may have been filed under seal. And so we may have to have a mechanism where they can make a request of the NTA to provide them information confidentially to the TA. Administrator, you may know more about how that mechanic works, but I've been informed that there may be an issue there. Anyway, those are the general provisions. To Member Decker, with any comments from the administrator, and to Member Decker's point, happy to have you guys swing at it.
Oh, yeah, just we'll open it up to any of the members that have comments.
Sure, I do. Section 2, sub 1D says allow the passenger to make payment of rates, charges, and fares through the use of an electronic payment processing system. What occurs to me is that they already can do that through credit card, if you consider that an electronic payment processing system. And since it's not defined, if what we mean to say is that they can make payment through an electronic ride-hailing system, I would suggest that we actually use that phrase instead of electronic payment processing system.
So concur with your comment. My purpose in giving the generic statement is I was trying not to, conceptually, I was trying not to favor one kind of technological method versus another. Are they paying, could technology be developed where they are paying for the ride, for the TNC ride through a curb, through the same credit card versus on their mobile device? I wasn't trying to pick a winner or a loser on technology. So maybe electronic payment processing system needs to be defined by either or both methods? Or is it your thought, Member Decker, that it should only be through the TNC's method of payment?
Well, what I was thinking is that they're already, customers are already allowed to pay by every other electronic payment processing system available. All we're doing is specifically adding one more, and what we're specifically adding is the electronic payment through the ride-hailing app. Ride-hailing app being, I think, probably generic enough in that we're not saying it has to be owned or used by a specific TNC or, limited to one specific vendor, but just however they hailed the ride is how they pay. And I think that's what we're trying to get at.
Okay. So your point is electronic payment processing system here needs to be defined as that deployed by the TNC.
I mean, my suggestion is that we just use the term electronic ride hailing system, because that's what we're referencing in this chapter, in this reg file, is enabling that ride hail system.
Okay. You think we don't need a new definition? Okay.
Right.
Got
it. Okay, moving on to section 3, sub 1, certificate holder may enter an agreement for access to the electronic ride-hailing system of a transportation network. I suggest that we change of to used by, because of a transportation network company kind of implies ownership as opposed to third-party services or vendors.
Good catch.
if Lyft or Uber decide to go through some third-party vendor, I don't think
Yeah.
we're trying to include that. Yeah.
Right. Or even affiliate. Yeah, right. Good point.
Section 4. It is unlawful for any driver employed by the certificate holder will use a taxi cab to perform any transportation service, et cetera, et cetera. Unlawful, this section is not sufficient for prosecution or enforcement. It's not unlawful other than in referencing this section. It doesn't violate another specific law that we're referencing. NRS chapter 706.885 sub 1 says that any otherwise subject to administrative fines, every violation of the chapter is a misdemeanor. So instead of saying unlawful, which could mean administratively, which in that case, what would the fine be? Or it could mean criminally, which in that case is it a misdemeanor, gross miss, or felony. I would suggest that we say it is a misdemeanor for any driver employed if we want to go criminal, or you could say generally it is a violation of this chapter for any driver, and then that would point to the general chapter penalties.
Okay. So my thought was I thought we should have both criminal and civil penalties.
So then you could say it is a misdemeanor for any driver employed by the certificate holder, which leaves it up to the administrator to make it a criminal filing or an administrative fine. But if you say it's a violation of this chapter, you give the administrator the authority to apply criminal or administrative fines and penalties, or to prosecute it criminally as a misdemeanor, which.
Yeah, so I think it should be a violation of this chapter.
Okay.
That's my view. Other members might have a different view. What is your view? The same?
Yeah.
Yeah, right.
And that's all I have, Chair.
That's it. Okay. Other members? Administrator?
Under section 5, you had brought up, if I'm understanding correctly, you're concerned basically on whether or not this would be a taxi ride or not, or a TNC ride. And if we look at either the 1P system or a 3P system, the 3P system has a break between the driver and the company. The 1P system does not. And so I would only want to approve a 3P system, not a 1P system. If that makes sense. Because I think it could be a TNC ride if it is under the 1P system.
Uh-huh. That's exactly one of the purposes of subsection 5. So are you saying we need to define 3P and say that it must, the technology must be a 3P system that does these things?
Yes.
Okay. Can you help us define that?
Sure.
Okay. I don't mean this very moment, so.
I know.
Anything else from you or Ms. Webb?
Not respect to this case.
Dan, before we leave section 5, I have a question. What does subpart 3 mean?
Subpart 3 of 5?
Yep.
Oh, might be missing some language, huh?
Because there is no section 2.
Should say the administrator has approved the agreement as provided. Subsection 2 above, every agreement has to be.
Okay.
I want to, my thought, Vice Chair, was that the administrator should have approval rights, not only of the agreement, but of the electronic ride-hailing system as that communications technology is being used.
I think you clarified what I was asking though. That's
Okay,
fine.
yeah, I left out a couple words, yeah. You were just being polite. Any other board member comments? Before I open it up to public comment, I know it's unfair, but Dag Feely, any thoughts so far? Are we, do you, go ahead.
I mean, so far so good. I think this is a good,
First
good
shot?
step. In section 5, subsection 2, I just had a question. You guys approve tariffs? It talks about the tariffs you guys approve.
Yeah, I guess maybe this should be,
Talks about the passengers will incur under the
no,
standard.
we probably should say rates, charges, and fares.
Yeah, it says the rates, charges, and fares that the passenger will incur under the standard tariff approved by the authority.
Yeah,
I wondered
But
that
we probably don't need the standard tariff because I don't. What I was trying to capture there, administrator, help me out. Don't we call it like tariff 1?
We have with respect to EDC.
With respect to what?
EDC, we call the surcharge going to and from the, festival, tariff 1, tariff 2.
So that's why I grabbed the term tariff and I put standard in front of it to make sure it wasn't a surcharge. So perhaps, does that need defining, or do we even need it if it just says allows the driver to concurrently evaluate the respective rate, charges, and fares that the passenger will incur, rates, charges, and fares approved by the authority that the passenger will incur, and that collected under subsection 5.
We could just say that the passenger will incur as approved by the authority. Then,
Yeah,
no.
we don't need under the standard tariff. It's surplus. It injects another concept without adding anything, right?
Yeah.
Dag Feely? Yeah.
it's good. I was also, might just be like a personal thing, but in sections number 1, it's the definition of electronic ride hailing system looks a little odd. That it means digital network or software application used to operate the electronic ride hailing system. Seems a little tautological, or is that the?
Yeah. To operate.
It's got the definition within itself,
Yeah, no, I agree with you. I totally agree with you. It needs to be application used to. Yeah, it could just be used by a certificate holder or a transportation network, the functions of which are. Right? Correct?
Sounds better.
Because it is a digital network or software application according to 706A. That's the TNC statute. So I think it's just electronic rights. It means the digital network or software application used by a certificate holder, or a transportation network company, the functions of which are.
Better to me.
Was that a question or a statement?
Oh, yeah, no, that seems to address my concern, I suppose.
Okay. Anything else, Dag?
Nothing significant.
Okay. I know that you will want to reflect on it more in light of the memorandum. Okay, would like to open it up for public comment if there's not any other materials from the board.
Athen Revelos from Curb Mobility. So be patient with me, please. I'll try to work through this. I appreciate actually, now that I have the understanding of how this document came to be, I appreciate the effort put into it. I think it's a great start. And I also want to say that the communication by the TA through this process thus far has been excellent, and I'm very comfortable, and I think I speak for at least Curb Mobility and probably to some extent our clients that we like being a part of this process. And we look forward to resolving it so that we can continue the programs and expanding the industry. So having said all of the niceties, section 2, yes, I have concerns about that definition. It's very, the flavor of that definition suggests that the fleet has a direct relationship with the TNC provider. And it also conflates, if that's the right word, it confuses two different e-hailing systems and not physically in the taxi, but in the consumer facing side. So there is a taxi hailing app, in our case, that's Curb. And with that app, consumers can only book taxis. Then there is the TNC app, in this case, Uber. And riders using the Uber app are booking a ride through Uber. And then Uber is referring that ride to Curb, who refers it to our partner fleets. So by that definition, which is the, not to be overly bold, but that it has been the industry definition of what this type of program is across the country, this section 2, number 1 is not appropriate. I don't want to go so far as to say what you should call it or you should not call it, but you have, even in the case, the rare case where a taxi company may own the technology that they're utilizing within their taxis and on the back end and for their APIs with the TNC, the technology is usually its own company, its own business. So, for example, you know, I'll go into Los Angeles, LA Yellow Cab, which covers most of Southern California. They also have been using a system called NTS. I think it's National Taxi Systems for decades. They most certainly, at least it's the belief of almost everybody in the industry, they also own the technology company since no one else uses that technology company and they've controlled it since its inception. And so going with that belief, their integration with Uber is with NTS. It's not with Yellow Cab. So you have 3P as you referenced. That's third party, our third party relationship. And so we need to be careful of that because I have done these, meetings and similar meetings and hearings of this nature across the Western United States, getting approval. And one thing, and I've done it, in concert with Uber and Lyft themselves. And the one thing that is very clear is that once that passenger is referred by the TNC to the technology provider and then to the taxi driver, once that person sits down inside of a taxi, that's a taxi trip. The only real issue once it becomes a taxi trip is the deviation from the tariff, right? So that's the structure. So these definitions here in section 2 obviously are very key in making sure that we have the right policies in place. And so, yeah, so you have 1A, facilitates a passenger connection by a wireless mobile communication device to a driver who is available to provide transportation services. My concern with this is the passenger is not connecting they're not connecting with their wireless device to the driver. They're using Uber, and then Uber is sending the offer to Curb, and then Curb is communicating it to the driver. And from that point on, anything that suggests that the passenger will be using, item B, presents for review and acceptance by the passenger using such wireless mobile communication device a complete and accurate statement of the terms, conditions, and charges. Uber is presenting that to the passenger. So Uber is presenting the fare total, the opportunity to tip the driver. The rider has already agreed to Uber's terms and conditions. And upon the first time that Uber refers that passenger to a taxi cab, the passenger has to actually agree to an acknowledgement to their terms and conditions that they're okay with Uber putting them in a taxi. And from that point on, then they can ride in a taxi. So that is done on the TNC app, not on the Curb app in our case. And then the same for C, record and present to the passenger documentation of the passenger fare charge. That, of course, is going to come from Uber, not from Curb. And then D as well, allow the passenger to make payment of rates, charges, and fares through the use of an electronic payment processing system. Transportation network company at section 3. Section 3, yes, it sounds like there's already a somewhat of a consensus that there may be some concerns with how this is written. A certificate holder may enter an agreement for access to the electronic ride-hailing system of a transportation network company. This goes back to the 3P argument. So really, the certificate holder, you might, if you want, that's going to depend entirely on what you guys as a board and what you, the administrator, how you want to approach this. But I imagine you could say a certificate holder may enter an agreement with either a TNC or with a taxi technology, or however you want to, whatever nomenclature you want to use for that, the taxi technology system. But they're going to enter into an agreement with somebody. If it's true 3P, it's going to be a taxi technology company, not Uber or Lyft. And, or most likely, I don't want to speak to things that don't exist. And then also that language needs to be that basically you just need to see an agreement or the something that shows that that taxi company is authorized to get TNC trips. If it's through Curb, or if it's through Captain, or if it's through AutoCab, or whoever it is, right, the vendor. Trying to move fast. Let's go to section 5. Again,
Did you say 5? You blipped out on my,
yes.
okay.
An electronic ride-hailing system of a transportation network company for which a taxi cab has access must be deployed using communication technology that, again, this just really needs to be structured and actually, yeah, this just needs to be structured with third party in mind. And I'm not going to reiterate what third party means at this point. Section 5, number 2, I agree with what seems to be the consensus by the board to strike under the standard tariff approved. I have concern that, it's still not clear enough that it may eventually, maybe even by another board, another chair, another administrator, be redefined as, because it may clash with NAC 706-471, depending on how you want to define line 3 in section 8. But I'll just leave that there. And then I see section 6 appears to permit for a deviation. The administrator for a good cause and upon a determination that the functionality of the electronic ride-hailing system of the transportation network company provides reasonably comparable information and documentation to it and for the protection of the passenger. So determination that the functionality of the electronic ride-hailing system of a transportation provides, I think this needs just a little more clarification. I'm not sure what it actually means at this point. And then the annual reporting, we have no problem with that as Curb. I mean, we are doing monthly reports now. We will comply. The application is from Tech and Tax. Yes, so again, section 8, number 4, for each agreement entered pursuant to section 3 of this regulation, the certificate holder shall file with the authority an accurate and complete copy of the application information filed by a TNC. Yeah, so this is going to be the tech company, not the TNC. And I think that's essentially it for me. I just wanted to give sort of a, I don't want to overstep and say this is, what you should think, but 3P, third party, it's a trip referral, right? So it's really, it relies, I'll give just the one last sentence here. This is I think a very descriptive way to put it. Third party relies on a bridge technology, and that's the third party. And if you don't have that bridge technology going through an API, you don't have 3P. Thank you for taking my comments.
Hang on, before you go.
Sure.
So I don't know how the NTA works. Are you saying that the transportation technology company also files an application with the NTA?
It depends on the jurisdiction and what their requirements are. So in the case of the NTA, I think we filed jointly with Reno Cab. In some cities, we file jointly with fleets. In some cities, we just have to file an application with the regulator, and then the fleets are able to work with us. And some cities just don't care. Yeah.
I would find it helpful if you could provide specific language that you would think is appropriate for the regulation.
I'd be glad to do that. Should I just submit that to the administrator? Luna, yeah.
Yeah.
I'll do that. Thank you.
Yes, to the administrator. Our regs currently cover the trips that are originated through Curb. I want to cut through a bunch of what he said, but I want to make sure I understand. the regs that are currently in existence already handle rides that are scheduled through Curb's app. But it doesn't need to be applied or kind of interspersed into what we're currently suggesting as changes, correct?
Great.
Okay.
And one amplification as we're thinking through this, to remember, we don't have statutory jurisdiction over the technology providers or over the TNCs. So whatever we do has to be based on some requirement we impose on a certificate holder.
Yep.
Because we don't have jurisdiction to regulate the technology provider. We can just tell the certificate holder we don't like how the technology providers. I mean, the legislature hasn't given us that jurisdiction, and we certainly don't have jurisdiction over the TNCs. So to the extent, I think many of your comments are very helpful, but to the extent that you're suggesting we assert jurisdiction over people that we are not legally entitled to, we can't, that regulation's not going to get approved.
Well, I hear that. I would use as maybe an appropriate example is the fact that the administrator has to approve our technology in the taxi.
But he does that by approving what the certificate holder is presenting to them for use. So,
Correct.
Yeah.
Yes, exactly.
Yeah. I'm just, as you're giving us comments back, think about that, because if you say we're going to start asserting technology over our jurisdiction over people we don't have jurisdiction over, the LCB is not going to let us do that.
Makes sense. Makes sense. Okay, before I try to stand up again, is it okay? Can I come in?
Sure.
Good morning again. Cheryl Gibbons on behalf of Desert and Virgin Valley, and Rich Frakes, General Manager of Desert Cabin Virgin Valley. And I'm very grateful for Curb for having gotten up here first and, you know, explaining the difference between us having an agreement with Uber, which we do not. Our agreement would be through Captain, and other certificate holders are in that same boat. So the 3P versus all of the other ways of taxi cabs performing trips via the Uber app is totally different. What's being done in Reno is totally different than what's being done here in Las Vegas. And the way that Z-Trip is doing it and the way that the other companies are proposing to do it is a much cleaner, separate way of handling it. It is literally a facilitation. The customer books the app, chooses a cab on the Uber app. Uber then is sending that information not to us, but to our tech company, which is Captain. And then Captain then in turn sends that ride to us through the DT5. So in looking at this first draft of regulation, and I thank the chair for this because it's getting us all talking about this and trying to move this thing forward, which we need to do for the betterment of the entire industry. A lot of this, I think, can be rewritten or proposed different language by the tech companies that are going to be facilitating this for us, as opposed to us trying to do this ourselves, because I don't even have all of the proper lingo. I don't think most of us into the industry do, but the tech guys, they definitely know what they're talking about. There were a few questions, though, that I had with regards to some of the language in here. Obviously, the language that is requiring the certificate holder to obtain Uber rates and Uber information from the NTA, I don't think is even something that we can do. I don't even know if the NTA has all of that information accurate on a day-to-day basis, much less than being willing to share that with us. So all of, Section 8, I would take issue with it, that we just wouldn't be able to jump through that hoop. And I think the chair has already said that Section 8 is going to be brought into question when he first introduced it. In Section 3, it references that the certificate holder has to tell the taxi cab authority the number of taxi cabs that will be equipped with access to this ability to perform these rides, and then to specify those taxi cabs that are operated by independent contract versus employee. Because although an employee is not authorized to operate as a TNC while driving a cab, they are authorized to perform these services under the agreement with the tech company that the tech company has with Uber. Everybody following me on now? Okay. So I don't understand why we would have a difference or want to know the difference between who is an independent contractor and who is an employee, when in a perfect world, every single cab, every single independent contractor, and every single employee will have access to perform these rides. So I just think that that language isn't really necessary, other than to say, tell us the cabs and tell us the employees and independent contractors that are involved. And most all the carriers are going to say every single one. Because, we're hopeful of that, this is going to continue to grow. Rich, did you want to take the next one?
Well, I just wanted to clarify that the independent contractors, because you kind of carve out a big portion of the driver pool when you do that, because I can only talk for us, but we have like 300 employees. So that means 300 of our 800 drivers can't do these rides if you carve those out. So that's a huge part of the fleet that you wouldn't be able to do the rides. And then if it is a P3 ride, it is a taxi ride. So it would be up to us how we would pay the driver, right? Whether we pay the independent contractor, well, we wouldn't pay the independent contractor. We're going to basically give the money that he booked, because they're giving us the money. We have to give it back to them. It's like a credit card, right? But the driver, we would have to figure out how we're going to pay the driver that fare. So we would run that through our payroll system so we could pay them. So I just wanted to make sure that I don't want one of my drivers going to jail because he did a ride as a employee when he was actually, he's not contract. He's just doing a ride that came through the meter, right? It's like doing a ride that gets sent to Cabot. It just sends it to him. He accepts it. He does a ride. It's done. It's a taxi fare. So I just want to make sure. I just want to get some clarification on that. So I didn't want to, I don't want to get too muddy in the water. But independent contractor and employee, you're carving out a big section of the driver pool, even in the whole rest of the industry.
Well, and I don't think that was the intention based on Section 4, since it specifically states that it's illegal for an employee to perform these types of rides unless under the guise of operating under the 3P system. So one has to go.
But the language conflicts each other. That's all.
Yeah, absolutely.
The language what?
Conflicts each other.
So you're talking about Section 4 where it says any driver employed by the certificate holder? Is that the language that you're specifically saying excludes leasehold?
No, that language needs to be there, because we know that employee drivers, unless they're operating through that 3P system, would be in violation of NRS.
Okay.
We want that language. What
Section 2
makes no sense is Section 3, A and B. If the authority simply wants to know, hey, Desert Cab, how many people are you going to have that are going to be able to perform these 3P rides? Desert may choose to say, we're only going to give it to 50% of our independent contractors and 50% of our employees, and these are the vehicles. More than likely, every carrier is going to say every cab I have, every medallion I have, and every independent contractor that leases from us, and every employee that is employed by us, because we want it open to 100% of the driver pool.
So I'm going to just tell you, I have a fundamental disconnect here. 1A and B provides to the administrator the information necessary to audit compliance with Section 4. If we know who the independent contractors are, we don't care about auditing them. They're able to do this. What we need to be able to do is know the following employees, and you might say every employee, okay, great, who would be audited for compliance with section 4. So if you don't like 3(1)(a) and B, I think it's incumbent on the certificate holders to tell us, okay, how is the administrator going to have some data set to enforce 4, to audit it?
I understand your point, Mr. Chairman. Wouldn't it just be simpler to say that the certificate holders must identify the employees and independent contractors that will be participating in a 3P program? Because the vehicle itself is defined by the medallion, whether it is a lease decal that is outward facing or the employee medallion side. An employee can now also be an independent contractor. So if it is simply that the authority is not privy on any given moment who is an employee versus an independent contractor, because they can do both, then it could possibly be where if a carrier wanted to change it, they would need to notify the authority. Other than that, all are considered to be a part of it.
But about the audit part, they can simply just request the trip sheets and look at the rides that were Uber rides or TNC rides. They can just pull the trip sheets and they can audit through the trip sheets. We have electronic trip sheets. Independent contractors and employees both have trip sheets, so they can request a trip sheet and they can look at the trip sheet and see if they were working, doing them on whether an employee or not. They would be able to look at. They'd be able to audit it that way. They can look at the car and see if it was working or not through the employee or an independent contractor by their trip sheets.
If that's the administrator of whatever mechanism, but 1(a) and B is to provide you some kind of an audit trail, I also don't know if you want to allow or you want to be required to ask for, but make them actually affirmatively provide you some kind of report that would allow you to audit compliance with subsection 4. That's the purpose of 1(a) and B, to get a discussion started about how can you enforce 4. And I don't expect you, Todd, necessarily have an answer today. I just, somehow there needs to be a regulatory hook on the certificate holders that require them to report to you something. You don't have to spend huge amount of resources to go out and do an audit that you don't have the staff and the funds to do, that they just have to submit. And maybe we're going to have to create some special kind of report by which you would audit for, that they have to file. But I get the industry's comment. My comment back is, okay, then what mechanism are we using? What are you filing that helps him enforce 4?
Right.
But-
Well, I'd like to just follow up a little bit. One of my cab drivers would never be driving the cab without my permission. So once they got in the car, they have my permission. I'm going to give them a trip sheet. They're going to get in the car, put the medallion. It's all going to be together. And then they're going to drive the car and they're going to bring the car back. So any rides that they do where they have my car, my taxi cab, then they would have permission to do those rides. Now, if they took the cab out, they stole the cab, and then they would go do it, then they would be under the violation of section 4. But if they if I gave them the car and the keys and all that stuff, and I gave them a trip sheet and they were working, employed by me, then I think it would be hard to enforce that section. That's my thought.
How do you prevent them from going off and using the cab, which is what the statute prohibits? How do you prevent them from just not entering a trip sheet or, using the cab for a purpose that you haven't authorized? which is then a violation of the statute and this proposed regulation.
Right, well, I mean, as right now, anytime they use the meter, even if they're logged in or not,
That's the point. They don't use, they go off the system and they use the car to actually be an Uber.
Okay,
Oh.
so,
well, that's, I mean,
Okay.
yeah, well, that would be hard for me to,
That's right.
anyone to
Right.
prove. I mean, it would literally be the authority catching them red-handed, doing
Right.
something like that, or, you know,
So do we have the, one quick question, Dan, hold on. In our monitoring through the Z-Trip, through the curb, through the captain systems, we have the ability to go on real time, right?
No, we don't have the capabilities to see in real time what rides are being taken and if they're being taken as a Uber or a traditional ride. The way we would do it is a lot like how Rich was talking about, is through auditing the trip sheets. But the biggest problem that we do have is when you see a big gap of time, you don't know what that person's doing.
That's right.
If they're hiring a meter, you can tell. If you've got a 2-3 hour gap that they're logged into their meter, you don't know if they're taking cash rides. You don't know if they're doing Uber. That's when enforcement comes into play, and we have officers out there checking. So if we start catching people doing it, then we start monitoring. There are ways through technology, through cameras to be able to look.
So the instant monitoring that you currently have in the pilot program, what information do you get from that?
I have the ability, due to the Uber program, I don't have any ability to live watch. I get reports. As the authority, we have the ability to go in and see their meters and at the audit trail of any changes in the system. That was part of the electronic sealing we were moving to. But as far as the Uber program goes, we don't have the technology to watch.
So, yeah, you guys can just still keep commenting.
So Mario Lacascio, General Manager of Deluxe Taxi, the confusion is right here. How you said over the phone. Well, if he's in this cab, the app won't work because the actual ride is coming through the meter. So he can't take it on the phone like you guys are saying. Those are two separate issues.
Why?
that's what I don't think that's what,
they're not using.
I think what the chair is trying to say,
Say I'm an Uber driver, and I have my own,
that's my,
why can't I just go?
that's what.
And I think that's what Dan's trying
No, I agree, I
to
understand,
control here.
I understand.
Is like that process, me just being the two hats thing. I'm an Uber driver on my off time, and then I just take a ride on my phone and use one of your vehicles.
But then the downtime and
I
the
totally
meter,
agree. I totally agree.
everybody would catch that. I mean, I would catch if a guy 3 hours didn't do a ride on the meter. So it would, but they would also.
In 1 second, real quick. So, Mr. George, sorry, I didn't mean to cut you off. Dan's trying to control the fact that we have to control whether or not they're collecting the appropriate rate, fare, charge, fee, and everything else, and to address Member Decker's concerns as to the statute in general.
And the
So I-
moonlighting rule.
Yeah, and the moonlighting.
Well,
Yeah.
how about if the language said, let me just read this chapter so we don't have to go through this, because this might hear it, might not. It is in violation of this chapter for any driver of a taxi owned by a certificate holder to use the taxi cab, blah, blah, blah. Does that encompass all of it? Whether it's leased or they're an employee isn't really what we're getting at. We just don't want them to use the taxi cab that's owned by you.
Right.
So doesn't that fix all of that?
I think maybe you take out employee, just,
Right. It is in violation of this chapter for any driver of a taxi cab owned by a certificated holder to use it except for as permitted under the.
That covers everything.
I think that covers, I think that fixes the rule.
Did you get that?
I'll listen to that.
Okay.
And I have to request,
Bill George was a driver cannot have two accounts. That's with Uber. So that's the whole thing that makes this impossible. And it's part of what has been the delay in signing some drivers up, because drivers that are now cab drivers some of them used to be Uber drivers. And so there was a problem, a conflict, because they're now registered with Uber to get the trips, so they're identified through that. They can't have two accounts. So that stops what you were referring to, that I can't be a cab driver and use my phone because I am then registered already through the cab company.
Said it a lot better than me. It's the team.
So,
No, it's a valid point, but
Double
there's
ping.
Lyft, there's Uber.
Right.
There's
Different ways
two
to see
other driving, TNC companies out there
Yeah.
right now.
But I think
So
what you
I get what
suggested
you're saying.
covers it, but I think
Yes.
a lot of it is just the way the system works.
I think we're driving down and spending too much time on whether it's a lease driver or, like, that's not really what we're trying to get at, I don't think, is it?
Right.
Yeah.
That was an issue, though. That there is a difference between a lease driver and an employee.
mhm.
Well, and
That-
that's
that-
because we have requirements under the regs to give statistics
Well, that
as
was-
opposed to a leased vehicle versus a company vehicle.
That was also
That's what I think
discussed,
Dan's trying to.
that was also discussed in that memo that keeps getting brought up that was prepared by Louis Soka. That relates back to your favorite issue of moonlighting. And so as it currently stands, just in the pilot program, are there any leased drivers taking part in the pilot program?
It's open to anybody.
Yeah.
And, okay.
Yes.
Yeah.
Okay.
But that's related to the statute I read off that the agency's going to address in the next legislative session.
And that brings up a point. The AG's letter, there were 4 points that have been referenced at prior meetings for those of us in the industry. None of us in the industry, at least I have not received that AG's opinion. Is that something that the authority or board is willing to share with the certificate holder? So that we can then maybe, delve into it a little bit deeper? Is that something that can be made public to us?
Well, it should be on the AG's website, available to anybody, right?
No, this is not an attorney general's opinion.
Yeah.
This is an attorney-client memo that was given to us.
Gotcha.
So I'm not inclined to waive the attorney-client privilege because it tells us all kinds of different things that we should be considering, and I don't know that that's any of the industry's business. That's my position. The board could vote
Yes, the answer-
against me.
Not the last time I'll be told no.
I don't have any other questions. I just wanted to clarify that, but that was.
So,
Yeah.
but before you go away, Mr. George, before you go away, I have a question. Are you, I'm just want to make sure I understood. So if I'm a taxi driver who also is an Uber driver, because the last time I was in a cab, I asked, hey, do you ever drive for Uber? And he says, oh yeah, I'm an Uber driver. Are you saying that he can't have an app on his phone that lets him drive as an Uber driver and an app on his phone that lets him drive as a taxi cab driver?
He's registered through our program with Uber, through our technology. He cannot be a regular driver,
He cannot be an Uber driver.
a regular Uber driver. He can be an Uber driver
be a
through
Lyft
us.
driver.
but
Right,
that-
he may only take Uber.
Through the cab company.
Okay.
It would
So-
create a, hey, that's why it won't, now you can fraudulently make another account with a different name. I mean, there's always fraud, right?
But he could still
But
drive for
under
Lyft.
that same, but under that same scenario, one unique driver is registered.
So I'm just gonna, other board members may feel differently. I'm just gonna put this out there. If there is not a solution, if the industry doesn't help us find a solution to the moonlighting rule, then the answer is pilot programs die because there's a law that we have to comply with. And it's not a reg, it's a statute.
Yeah.
Path and Revelos curb mobility. The Uber driver app, for a driver to use the actual Uber driver app as no taxi, just on their own, right? To get approved on the Uber app, they have to first get the vehicle that they're driving approved by Uber.
Yeah.
They have to get that physically inspected. That taxi cab would never be approved as an Uber. So even in the event that the driver maybe has their Toyota Corolla and they get their Toyota Corolla approved and for whatever reason they can't use or don't want to use their Toyota Corolla, they have the cab and they decide, well, I'm going to be smart. I'm going to use this Uber app while I'm in my cab. That won't work either, because what happens is when you order an Uber as a consumer, it tells you the vehicle type and the license plate number. I promise you, within the first 3 rides, if he even gets that deep into it, he's going to be reported to Uber and they're going to suspend him.
And in the end, that would be the only scenario we're really trying to address, and it's
Yeah.
relatively possible for those reasons. So I really don't, I think this is kind of a non-issue.
Agree.
Would have a lift car somewhere. Is that correct? So they
Yeah,
can still have
but-
that Toyota
But
Corolla.
it's gonna be a separate.
But that's not gonna be the tax system.
So they have to quickly drive home and go switch cars and then do it.
Somebody may not know the difference between a Camry and a Corolla. They know the difference between a Corolla and a taxi cab.
Yeah.
It's marked, so it's such a blaring difference.
Yeah.
So does that mean that they're disabled, or they just get caught if audited by Uber? I just want to know.
Well, I think it more, so
Right.
the problem with Uber doesn't exist. The problem we're discussing doesn't exist with Uber because you can only have one registration. Now, if they were using somebody else's phone and doing something like that, that's a totally different story. As far as Lyft is concerned, somebody could theoretically be registered with Lyft, have their phone in the car, but as was pointed out, the first time that Lyft would not register a taxi. And so when you see the photo of the vehicle or the type of vehicle on the license plate, it will not be registered as a taxi cab. So the customer would see, I'm looking for the example, the Corolla, and a marked cab showed up. That's going to create an issue that driver will immediately be deactivated from the Lyft.
And a different license plate
And then,
number.
yeah, different license plate number, plus you've got cameras in our vehicles that are gonna be able to detect, there's a lot of ways to detect it. So could it happen once? Maybe.
Yeah, I can say it's not been an issue in any other markets. In LA, San Francisco, Reno, wherever else I have.
Yeah.
Yeah.
And this is
New
what
York.
we learned this when we started first signing up drivers, and we were having a hard time getting some of them because a lot of them previously had accounts, and that's really what tipped us off to this issue. Thank you.
Any other comments or on the draft? So, questions or additional comments from board members?
Sure.
So, Administrator, I guess I have a question for you and Ms. Webb. Did you receive enough information to draft proposed changes?
Yes,
Or-
I think we
or
have
did
enough information to give it another good shot and get something out. Yeah.
Okay.
And I think also there, I would entertain language from the industry, like you pointed out. I think they need to be involved in this as well.
Yeah. Okay. Anything else by board members before we close the workshop?
I think we still need to go over the small business.
Oh, yes, thank you.
Yep.
So, somebody correct me if I'm wrong, we'll open it up for any industry comments relative to the small business impact statement.
My understanding, just for purposes of the record, it's my understanding that the industry has submitted a white paper modernizing the taxi cab industry. It's dated February 11th, 2026. It's in our packet and we all have read it. It's been submitted by Uber. Excuse me. Thank you. Anybody have any comments or anything like that? All right. Sorry, Dan. Go ahead.
No, thank you, because I don't have that in front of me.
Yep. we've seen or
Okay.
on the,
Is there anything else to come before us in the workshop? If not, I think we can entertain a motion to adjourn.
they get another, we have to do the public comment.
Oh, yes, thank you, public
Yeah,
comment.
yeah.
I didn't hear the first public comment because I wasn't admitted yet, so. Is there, this matters on the agenda for the purpose of taking comment from the public on matters within our jurisdiction. We can take no action on it. Any public comment? Any public comment? Seeing none, closed. Now I will entertain a motion to adjourn.
So moved.
Seconded.
All those in favor?
Aye.
Okay, thank you.
You.
Yeah.
Thanks, Ann.
You heard me.